Good evening, everybody. Hope you're all doing well. It is March 25th, 2026, Wednesday evening. And again, I hope everyone's doing well. I'm in Atlanta, Georgia. Weather's actually been quite nice. It was in the, I think, high 60s, low 70s. It's going to get a little warmer this weekend, but looks like spring has sprung. So I think all the cold weather that we've had this winter, we had a very cold winter here. I think it's over. I know some places in the Northeast are still dealing with the cold. And if you're in the Midwest, Great Lakes area, I suspect you're probably dealing with it as well. But for now, we are things seem to be warming up. So that's a great thing. I hope everybody's well. I had an interesting week this week. I had 4 hearings yesterday, which is kind of unusual. I had had no hearings last week. My daughter was due last week. She ended up giving birth on Monday to a healthy baby boy, which is great. But the last week we were expecting her to give birth, so we can schedule our hearings. I didn't schedule any hearings, and then I just put Tuesday. I didn't put any limit on it, so they gave me 4. It literally started at 9 o'clock in the morning, and I went all the way through 4 o'clock. I think they all went pretty well, but it was a long day, and I was pretty exhausted mentally at the end of the day. So I don't normally like to do that, but I prepared way ahead of time, had my briefs filed, my notes filed, and so we were ready to go. But it was definitely a long day yesterday. So I know that some of my colleagues are talking about Social Security really pushing them to they're apparently in some places they're denying cases at reconsideration very quickly within 30 days, which is very unusual. Normally it takes 5, 6, 7 months. They're doing it very quickly to get to the hearing, and then they're pushing attorneys to schedule more hearings. And again, I don't mind doing 2 or 3 a day, but I don't like to do, I wouldn't want to do 50 hearings in a month. That would be a lot for one person. So we'll see how that works out. I mean, I can do 20, 25, but 50 would be a bit much, but it hasn't happened to me yet, so hopefully it will not. So anyway, enough yapping about me and my schedule. Let me go to some of the questions here. Haq Assad, who's here pretty regularly, says, good evening. Thank you very much. You're very welcome. Once a claimant, it's a good question here. Once a claimant is approved for SSDI, would you advise that they download a copy of the CDR form 454, which I think is the long form, and tailor their doctor visits based on the requirements of that form? And it's essentially just it's kind of a form asking about medical information and doctor's visits and tests and things like that. It's probably not a bad idea to look at that. I don't know that I would make any changes in terms of treatment. Realize that the way the CDRs work, I know people have a lot of questions about CDRs, and I'm going to try to answer them as best I know. First of all, one thing that you probably have heard is that the whole CDR process is going to be centralized. It was being handled out of local offices. Now it's going to be in one main national office. And as I mentioned last week, I think the purpose of that is to increase the number of terminations. It doesn't mean you're going to be terminated. It just means that that's the goal there. And certainly if you're under 50, you should be concerned, because I think those are the people they're going to go after. I think over 50, especially over 55, probably not as much of a big deal, but certainly under 50, it could be. And really the key is continue to go to the doctor, continue to pursue treatment the way you've been pursuing it, take the medications that are being prescribed. If there's procedures being suggested, give it a legitimate look. I mean, again, no one's going to expect you to undergo a major surgery. That's not, they're not going to punish you for not undergoing, triple level, 3-level fusion on your back. But certainly if the doctor is talking about surgery, you need to consider it. I think really the key is just to continue to go to the doctor. And if the doctor will assist you by helping to identify some of the functional limitations, that would be very, very helpful. So I think that I wouldn't model my medical treatment on anything in particular other than just getting better. I think that it's a mistake to try to make your treatment designed to address a Social Security need. I think you focus your treatment on getting better and improving yourself, and ideally getting back to work. Look, I mean, I do this for a living, and I think everybody here is pursuing disability because you've got a legitimate reason to do so. But if you do get better, you're going to be happier going back to work. You're going to be feel more fulfilled in life. Your family will be happier. It'll be more of a sure thing. So by all means, if you can go back to work, you should. So again, I think the important thing here is just to pursue treatment that will get you better, and let that take care of the underlying Social Security issue. Because if you remain unable to work and you're undergoing treatment, then if they try to review you, you're going to get the same result you got before, which is you will be approved. Now, I would, if it's at all possible, if you have doctors that will help you, have them address or note in the record specific functional issues, things like standing and walking and sitting and lifting, and you want them to identify what you can do. Another thing you could do is look at your records and see if the doctor is not making any changes in his or her notation or history. What I see a lot of times is go to the doctor, let's say we'll just use March of 2026 as an example. You go to the doctor in March of 26, and the doctor sees you once a month for the next 3 years. And in February of 2029, you look at your record and it says the same thing it said in terms of the history as it did in 26. Sometimes doctors don't update that. So I think it's worth looking and ask your doctor to update that if you can. I think that if there has been medicines that you didn't tolerate, make sure that's in the record. Just want to document things. Doctors are focused on getting you better. And sometimes, if they may shorthand, medication not successful. Well, if you were throwing up, 3 times a day for a week you tried it, that's different than not tolerate. So you want to be more specific. Keep a calendar. I think that's not a bad idea. A pain calendar, a symptom calendar. Those are the sort of things that would help you. But again, the biggest thing is just go to the doctor, pursue treatment that's being suggested to you, and just give it your best effort. And I think if you do those things, you don't need to worry about the form. That'll take care of itself. And again, just be aware that if you are under the age of 50, you may see some more activity on the CDR front. Okay. Naisha Smith, I love the content. Quick question. Already been approved? That's great. Working a part-time job, planning to move to a different state in a couple of months, but get the same amount. Is that okay? How do I notify Social Security? What do I need to tell them? Thanks you again. Naisha, I think that the important thing is when you report it, go to your My Social Security portal, ssa.gov/myaccount, and you'll see a place there where you can report your earnings. I would keep track of it on a spreadsheet. Know what the figures are for both trial work period and substantial gainful activity. Trial work period in 2026 is $1,210. So if you earn $1,210 or less, you don't use up a trial work period month. That's good. If you go over that figure, which again, part-time work, maybe you do, maybe you don't, you have 9 months you can go over it without having any impact on your benefits at all. Where people get messed up is they may have a job where they're getting paid every 2 weeks. And in a biweekly pay period, you may have some weeks some months you get 3 pay periods, 3 paychecks. That could take you over that. So you want to keep track of your earnings. It's the month where you receive the earnings, not that you do the work in February, you get paid March, that counts towards March. So you want to keep track of that. And, if you used up your 9 trial work period months, it's a rolling over 5 years. So it's a rolling 5-year look back. So if you use up a trial work period month in March of 26, in March of 31, it'll fall off. And again, it's a long way away, but if you're kind of, a couple of months here and a couple of months there, you may find that you can roll off some of the previous months and you have more that kind of come into the, you have more available to you. The problem is there's no real-time way to see have you used up your trial work period months. And that's a flaw, in my opinion, because, if they're trying to encourage people to go to work, it would be really helpful to have a place you could go online at your My Social Security portal to see how many trial work period months you have left. They don't do that. So you have to keep track of that yourself. More important, in my opinion, than trial work period, though, is the SGA, which stands for Substantial Gainful Activity, $1,690 a month gross. Again, that's before taxes. In 2026, it'll go up in 27. It was a little bit, it was 1610 and 25. And so if you go over SGA after you've used up your trial work period months, so while you're in trial work, doesn't matter, you can go over it. Once you use your 9-month trial work period months up, then you go over SGA, you get into overpay status. That's where you run into trouble, because you may go into overpay status, they don't tell you for 2 years or 3 years. And, you get this letter in the mail saying you owe us $30,000. And you have to really keep track of it. Again, no real-time way to keep track of it. So you need to really look at your earnings, your gross earnings. Now, there are a few exceptions where you can, if you have expenses that are directly related to your ailment, your impairment, that can come off the top. But again, you've got to report that. But let's set that aside for a second. I think you just need to keep a spreadsheet of your gross earnings month by month, every month since the time you get approved. And if you start, and know the figures, know the SGA, 1690 in 2026 and the 1210 for trial work period, and just keep track of it as best you can. I will tell you, a lot of people get very frustrated with this because there's no real-time reporting. You don't know where you are. If you haven't kept track of it, you may find that 2 years from now you decide you want to try to work, but you have no idea where you are in the system. You can't get through, and even if you could, can you really trust what they tell you? It discourages people from working. That's what the bottom line is, which I think is a real a pity. They shouldn't discourage people from working, but they do. So I think that this is just one of those things where you just have to really just keep track of it on a spreadsheet on your own, do the best you can with it, and hope that you don't, get into overpay status, because that is not a good place to be. I've had people, get these letters saying we owe us all this money. Not a good thing. So some people just figure it's not even worth trying to work. But I think if you are working part-time, just know what your gross earnings are and be aware of that 3 paycheck months, the 3 paycheck months. Rodney, one of our longtime clients. How are you doing, Rodney? Hope you're doing well. Cynthia, one of my clients. Hope you're doing well, Cynthia. Let's see, we got both Naisha and Cynthia say good evening to all. We've got Michael saying hello, Michael. We've got Chiquita Johnson. Hello, Chiquita. Hope you're doing well. Versatile offers blessings. Thank you. Congratulations. Yes, my wife and I are thrilled. We have a 2.5-year-old granddaughter who's very precocious, very opinionated. I will tell you, we've had her, while my daughter and her husband were at the hospital for a couple of days, we had my granddaughter, and she's, when you're in your 20s and 30s, having a 2-year-old is one thing. When you're not in your 20s and 30s, it's a lot of running around and, trying to negotiate with a 2.5-year-old. I mean, she's very precocious, but, when she doesn't want to do something, she doesn't want to do it. So it was an interesting couple of days. And, she would get up at 5:30 in the morning and start singing. And we have, of course, the monitor, and we're trying to get sleep, and she's having a good old time. And, so yeah, it was an interesting couple of days, and I just it's kind of a blur for me all those years ago when my kids were young. But my daughter and her husband are going to be dealing with it, and we see them all the time. They live very close by, which is a real blessing to us. But it's having a newborn and a very active 2.5-year-old is going to be it's going to be interesting. So we're going to have you have to have fun with it. You have to have a good time with it. And so far, my granddaughter is being a really great big sister, very loving towards the baby, and no jealousy. So that's a good thing. So all's good. But thank you very much, Versatile, for your good wishes. Sarah D. You're debating should you appeal the hearing decision, 30-page denial. The vocational expert did not take into account the extra breaks and days missed from my FMLA file. I was also working, let's see here. 4 hours at my previous job, not 6 like the vocational expert said. Should I appeal? My lawyer doesn't want to help with the appealing, so you have to do it on your own. Well, I wouldn't do it on your own. I think that there are people out there. If you email me, I'm more than happy, Jonathan at ssdanswers.com. I'm more than happy to give you the names of people that do appellate work. I know Andrew Sindler, who's been a guest a couple of times. He'll take on other people's cases. I've worked with Carl Osterhout. Lindsay Osterhout's been on here a couple of times. There are plenty of lawyers who do it. I don't really do other lawyers' appeals. I'll do my own, but not others. But there are plenty of people, and that's what they do. Again, Osterhout, Carl does a lot of them. And so I would have them look at it. The important thing is, the standard for review is more about the judge's analysis as opposed to, if the facts are completely wrong, that's one thing. But again, if you testified, I had, what did you say? I took 4 hour, working 4 hours instead of 6 hours. Is that material? I don't know. I'm just saying is that the appeals counsel is going to ask, would that really make a difference in the decision? And a lot of times they'll give a judge's conclusions controlling weight, even if they're not exactly accurate, because again, certain things, if it's a part-time job, it's really more about the money you make. 4 hours or 6 hours may or may not be important. But again, I think that's something that you would ask an appellate person to take a look at and see if they feel there are grounds for appeal. I'll give an example of one where we were successful in appealing it. The judge made a finding that my client was limited to fingering and handling occasionally. And occasionally in the Social Security world is a third of the day. In her hypothetical to the judge, she said frequently handling and fingering. Frequently is 2/3 of the day. So she made a finding of 1/3 of the day, and she put in her hypothetical to the vocational witness 2/3 of the day. Well, that's inconsistent. And the appeals counsel said, you can't make a finding of one thing and then have a different hypothetical for something else. That was reversed. That was an example of something that could be reversed. I've had other situations where a judge did not consider there are certain medical issues that were found to be severe medical issues, severe meaning that they have some impact on one's functional capacity, and the judge did not include it at all in the hypothetical. The person has, let's say, decreased cardiac function, and the hypothetical only asked about back problems. Well, that's an appealable error. Those are the sort of things they're looking at. So it's typically inconsistencies where the judge will make a finding or make a determination of the evidence shows one thing, it's not included in the hypothetical, or the hypothetical is inconsistent internally with the findings of the judge. But it's real, as you can see, it can be very picky to find those kind of things. And many times when I ask Carl or one of my other colleagues to look at it, they may come up with the conclusion, yeah, there's an error here, but it wouldn't have made a difference. The judge's hypothetical would not have changed, or there was enough other things in the hypothetical that would allow this person to return to work. So therefore, it is not appealable or not likely to be successful in appeal. Realize that, when an attorney takes, like a Carl Osterhout or an Andrew Sindler, other people out there that do these, when they take a case for appeal to the appeals counsel, they kind of assume the appeals counsel is going to rubber stamp it. Then it goes to district court where they've got to file a lawsuit in federal district court. That's a lot of work. And if you're going to bring somebody in to do it, number one, they're going to want your prior attorney, your hearing attorney, to withdraw and waive fees. And number two, it's got to be worth their while, because if they go through this whole process, draft an appellate brief, make an argument in front of a federal judge, and it's denied, they don't get paid. If they do get paid, by the way, they're the fee would be, they can ask for a fee. Typically, it's going to be still the 25% contingency. There's no cap on it. There's no $9,200 cap. So it could be a little bit more money as well to the attorney, because again, federal court work is sort of a different ballgame. Again, I'm giving you more than you wanted to know, but I think you should have somebody as quickly as possible look at it for possible appeal. If you want to email me, again, Jonathan at ssdanswers.com. I will be more than happy to give you the names of several people who I think would be a good to look at it, at least give you an opinion. And you may still decide that you want to do it on your own, but it's just going to be very, very hard to win. Mark, how are you doing, Mark? All right, it's been a bit. And I think we have a hearing coming up again, if I'm not mistaken. Let me just take a look. So I was thinking about you the other day, and let's see. I think I saw it. Yes, we do have a hearing in July. So Mark, I'll email you, but we have a hearing in early July with a judge with a much higher approval rate than the one last time. So that's good. Good news there. Okay. Could you speak to divorce, children in custody, and let's say a positive decision? I think what you're getting at is child support. And this is I can only give you kind of general information, and that is that if you are approved for disability and you have minor children, they would be entitled to what are called auxiliary benefits, which in general, depending on how many kids you've got, will be an amount equal to about 25% of your benefit amount. So if your benefit is $1,000, they'll get $250, not out of your $1,000, but in addition to your $1,000. If you have two kids, they would be $250 each. They would be $500. Then there's something called a family max, which would, if you have more than, I think, 2 or 3 kids, it starts reducing the percentage. But bottom line is that you get auxiliary benefits if you have minor children. The question is, that people always ask is, will that reduce my child support obligation? And the answer is, it depends. In some jurisdictions, it will, because the argument is that, you are, by winning your disability benefit and you're getting money to them based on your earnings record, this is like you're paying this. And, if you have to pay it in addition to the child support, that's an unfair windfall to the custodial parent. But other states don't see it that way. In some situations, it should be addressed in the support order. Other times, you may have to go back to court and get in front of a divorce judge and say, okay, I've been approved for disability. This is all I've got coming in, number one. That may change what I'm obligated to pay. But more importantly, I've got auxiliary benefits that needs to offset whatever, I'm obligated to pay. And you may have to get a judge to make a decision. But that's going to be case by case. So I can't really give you any specific, answer, because it's just going to depend on the jurisdiction where the divorce happens, child support happens. Custody, I don't know that, it's going to bear on custody. I mean, I've had people ask me, well, if my underlying condition is X, is it mental health, is it cardiac or whatever, would that bear on custody? With the idea a judge might look at it and say, well, this person is not as stable, or this person is, likely to have a need for ongoing hospitalizations, and that could affect custody. That, again, is a state question. It may or may not. I've not heard that it does, but it may or may not. As far as divorce is concerned and alimony and things like that, if you're on disability, I think you've got a pretty good argument that this is how much you've got coming in, what you were making before. And a lot of states use a formula based on what your earnings were before. That seems to be less relevant because you're not earning that anymore. And you're on disability. That's the new reality. So I think that would be something that a divorce judge would have to consider. You need to have an attorney who does divorce work in your jurisdiction. Do the research and find out, what implications of Social Security disability are, what they would be on child custody, on child support, all that kind of stuff, because it's just going to depend. And I would also tell people that if you're sort of in the middle of pursuing disability and you're going through a divorce, talk to your attorney about having it written in the order that what happens should you get on disability. Much better to be proactive about that than reactive, because again, the ex-spouse is probably not going to want to cooperate very much at all. And you've got limited money coming in, and you're trying to support your child or children, and you also have to have enough money to live. And of course, there's an insurance factor too. Sometimes in support orders, you're required to pay insurance. Well, you're not going to be able to get insurance for yourself if you're on disability for the most part. You can get Medicare at some stage, but that's not going to help your dependent children. You can see it gets very complicated, but I think talk to your domestic relations attorney about this. I hope I know it's kind of a wishy-washy answer, but that's the best I can do. Mary says, congratulations. Thank you very much, Mary. I am very happy as well. Let's see. Hey, Christy, how's my daughter? She is doing remarkably well. I mean, obviously, you give birth, it's, it can be a little uncomfortable, but she had a pretty easy delivery. And really was not in a lot of pain. We actually went out to dinner. There's here in Atlanta, there's a restaurant called Provino's, which if you look it up, Provino's in Atlanta, there's sort of this urban myth that if you're pregnant and you're overdue, you go have eggplant parmesan at Provino's and you'll go into labor. So we figured, well, what the heck, why not? So we went to Provino's on Saturday, and on Sunday she went into labor. I don't know if I'm going to get a free meal from Provino's or not, probably to reach out to them, but I don't think that's why. But in any case, she actually had a pretty relatively easy time of it. My daughter is a very disciplined person. She's kept herself in very good shape, worked out really until last week, eats very well, and exercise, just very, very consistently. So it doesn't surprise me that she had an easier time than a lot of people do, but thank you, she's doing well. And, she's adjusting to now, things are getting back into place, as it were. But yes, she's doing very well. But thank you very much for asking. What in the world is in the reconsideration phase? I'm asked to resubmit functional work forms again. Why do they need it again? A, they want to see if something's changed, and B, they want to give you busy work so that you won't complain to your congressperson. Maybe that's a little cynical, but the adjudicator doing the reconsideration evaluation is different than the one from before. It could be that your previous form did not go into enough specifics, or there's a question about whether something has changed because of medical treatment you may have received. I don't know that I would worry about why they give you the new forms. Just fill them out as best you can, which is, by the way, why I tell people keep copies of the forms you fill out. You may see those forms again, and if nothing has really changed, just recopy it. I would tell you my recommendation is go online and find the form and type it out. Social Security is paperless. They scan stuff. Trying to scan a handwritten document with all kind of notations on it about, answering questions, very hard to do, and stuff gets missed. Much, much better if you could go online, type in the form number, use your, even a Adobe Reader or Foxit Reader will allow you to type the answers in. It's readable, it's legible, and it'll do a lot more good than handwriting it. So I would tell you that may be another reason. Maybe it was handwritten and it's not readable. I mean, I was looking at one the other day, and my client, and again, my client was trying to be as descriptive as possible, which I appreciate, but this person had written in the margins, on the back, on the top, arrows being drawn. I mean, there's no way that a computer program would ever figure out what was going on with this. And, I even suspect an adjudicator is going to be looking at this going, I don't have time to try to figure this out. Make it easy. Again, type it out. If you run out of room, attach an extra piece of paper typed out. We describe in detail, your limitations on standing and walking and lifting and carrying and, the need to lie down. Be very specific, 10 minutes, 15 minutes, 2 hours. Avoid not very long, not too far, things like that. I think that's what you really want to do. And it's possible that the first go round it was not there, or that they couldn't read it. But to use this, my point here is use the fact they've asked you for these forms again as an opportunity to really hammer home the very specific problems you would have trying to be reliable at a job. This is Sarah D. I think you're the one who asked about appealing. If you file a new application with your attorney, have to waive fees or automatic with your application. I believe if it's a new application, your attorney would not need to waive fees, because I think that's a new application. Let me give you some thoughts about that. And again, what we've got here is a person who just got a denial notice, presumably within the 60 days to appeal. And she's wondering, should I appeal it or should I just file a new application? My feeling is very strongly, have somebody look at it for possible appeal. You're much better off keeping that other case alive. And also but if you decide not to, look at the decision. What is your date last insured? Because if your date last insured is already passed, and that's the last date your insurance credits have, it'll be in the decision when it is, and you file a new application, you're out of luck. You have no SSDI credits. So you definitely want to be careful about that. Point number two is that when if you reapply, the earliest date you can choose as your onset date is the day after the unfavorable decision. Anything before the unfavorable decision date is considered a thing decided, or res judicata. So it won't be relitigated. So, if you felt like I had a really bad judge or unfair judge, I've now moved, I'll get a different judge in a different location. I'm going to go back and have them take a look at what went on in 2024 and 2025. Not going to work, because the judge is going to say, well, you got a decision in March of 2026. The earliest onset you can have is March, whatever, 15th or 16th of 2026. That's the earliest you're going to get. So you're giving up a lot of potential past due benefits if you file a new application. Third point I would make is, it goes along with the second about the new onset date. What has changed? I mean, in an unfavorable decision, you are found not disabled through, again, let's just use March 15th. Now you file a new application saying on March 16th, I became disabled. And I realize that's not exactly what you're trying to do, but that's in effect what you're doing. And so a judge looking at it, and it'll be the same judge if you haven't moved, by the way. Well, what changed between March 15th and March 16th? Obviously, nothing changed. And down the road, maybe something changes and you may get an onset down the road. But I think that, if you're going to refile an application, there needs to be something different. Maybe you had, while you're waiting for your decision, maybe you had a terrible car accident, which I hope you didn't, but let's say that happened. Now back problems are in play, or you had a heart attack. Now you have some new things in play, but if nothing has changed, you're going to get the same result. So I just think that, when you're thinking about filing a new application with or without a new lawyer, what has changed and what's different? Why would you get a different result this time? You may not. And again, I think I would exhaust the possibility of getting the prior unfavorable appealed and remanded, as opposed to just filing a new application. I see some of those people file one after the other. I'm thinking, well, filing a new application doesn't change the calculus at all. What has changed medically? You got to show something has really changed medically, or it could be you changed your age category. So let's say, your 50th birthday is in June of 26 and you file a new application. Well, now you have a grid rule that could apply. That could be a difference. Or you turned 55 in June of 26. That could be a change. So it could be a new medical problem. It could be a change in age category where you meet the grid rule. So a lot of reasons why you could reapply, but the big thing is, the big question that a judge would ask in case number two is, what has changed? What has changed? P. Brown, thank you. Absolutely. We won our Lyme disease case at Initial very much. Absolutely. Yes, I saw that. That was great. Lyme disease cases are tough. I've had a number of them that I've won, and you really have to prove, obviously, that you had the Lyme infection. And, again, sometimes you got that bullseye look where you can definitely tell you've got it, or you take a test and it shows that the Lyme disease, is there. But it's also one of these conditions where some people have really, really bad limitations. Others have minor limitations. How fast do they get the antibiotics in you? So a lot of it is, and I think, age is a big factor, and the severity of the impairments. I mean, I know people, I have a good friend actually who's had Lyme disease, and this person's immune system is basically wiped out, gets sick all the time. And it's just, Lyme disease can really be a bad news if it's not properly treated. In fact, I had a case one time where I had a client, and he lived in, this is 10, 15 years ago. he lived in Virginia, and he was in Atlanta for a while. This, again, we were doing local. He moves to Virginia, and he's like, "Would you fly to Virginia to try this case?" And normally I wouldn't do that, but I'm like, this guy, he deserves to win. I mean, he went to Lyme clinics in Arizona. I mean, he was going everything he could do to try to get better. And I really respected that. And so I actually went to Virginia and tried this case before this kind of wacky judge, and she approved it. We had all kind of statements from Lyme specialists in these clinics all over the country, and she agreed, and she paid the case. So yeah, those can be tough cases because there's a lot of subjectivity in it when they're talking about the symptoms. And I was thrilled to see that your case was approved, because yeah, that you were certainly deserving when I looked at the record of it, and I'm glad that they did approve it. Chan, how you doing, Chantet? Does the CDR switch from the state to the new federal? Does it change your process as a short form? Only changes the process of the long form. I think that they're going to do everything out of the national office. Now, I have not seen anything in particular. What I do know about the short form, which I think is the 455, is if you answer no to all those questions, and again, they give you you got to put a X or a check or whatever it tells you, and it's machine read. And if the machine basically sees no, 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 no to everything, then many times there'll be nothing further done. It'll be processed electronically as disability benefits continue. So, but I think it's all going to be done out of a national office. I don't think anything that's going to be kept local. Chrissy, I'm 60, worked 25 years doing arduous work. My case is federal quality review from initial. They said it would take 7 to 10 days if they don't move. My onset date's a pretty good sum. Is this a good sign? Again, I'm not thrilled that they sent you to quality review. I do want you to take a look at something. Let me get you the site to this, because you mentioned the arduous work, and I just want to make sure that they're aware of it. Give me 1 second, and I'll get this for you. Okay. Arduous, unskilled work. Okay. All right. So basically what this is a POMS regulation, and POMS is sort of it's a program operations manual, but there is a POMS regulation, and let me share my screen so you can see it. Share screen. Well, I do not see it there. That's interesting. Huh. Okay. Well, a window. Let me try it here. I think we can see it there. Okay. This is the POMS regulation, DI 25010.001, and it talks about arduous work. And what it really says here is that this says 35 years. If you've got a history of 35 years of arduous, unskilled work, I mean, physical type of labor, and you can't do that work, then you're disabled. Now, you did 25 years, not 35 years, but I think I would still reference this POMS regulation to say it's 25 years, but the principle applies. I did this heavy, heavy work. It wears you out. I mean, my body is just basically worn out. And even though it is only 25 years, the principle, Social Security recognizes that a person who does, decades of arduous, heavy labor work, that they're likely to be disabled. There's not likely to be something they could do, not many transferable skills. I mean, the grids could apply. So I just think I would throw that in there. Again, it doesn't fit exactly, but in the law business, you learn if it doesn't fit exactly, you say the principle still applies. So I would say the principle of this DI 25010.001 is or just the POMS regulation on arduous, unskilled work. I think it applies. And even if your work was a little semi-skilled, or you did it for 25 instead of 35 years, I'd still throw it in there and, make them think. Because again, what this is really saying is, to Social Security, as a matter of policy, we recognize that people who've had a long work history doing really heavy physical work, they're going to be a worn out worker. And even if they don't exactly meet this, the principle applies. So I would probably, just make a note to them and submit it if you can. I'm aware that Social Security has a regulation, this DI 25010.001, talking about 35 years of arduous work. I've only got 25 years, but the principle applies, and please apply the principle. It's kind of like with the grid rule. If you are, the grid rule applies at age 50 and at 55, but if you're 54 years and within a few months of the next age category, they can apply the grid non-mechanically. Same thing here. Apply this arduous worker rule non-mechanically. And if they do that, that might help get you past federal quality review. Because there's nothing more frustrating when you get approved by an initial and then the quality review says, no, send it back. I think you want to be, you're that close to being approved, just push it. I would say push it if you can. Okay. P. Brown, thank you very much. Darlene, absolutely. And Darlene, I'm not saying anything she wouldn't tell you. She had Lyme disease, and she knows that, what it's all about. And so she is a great resource for people who are really struggling. But thank you very much. Thank you very much. Shauna, how are you doing? Absolutely. That was, we had a hearing, one of my 4 yesterday. We had a really nice result. Shauna did a really good job at the hearing, and we're getting a favorable. So that's great. Good to see you here, Shauna. And you did a good job. Okay. Okay, Dr. Wright, case sent for quality review as a denial. Quality sent it back to the federal quality review, sent it back to DDS, asked a lot about my last job, and I was going back to the doctors for review. Right. Well, now, again, this is one where quality review pulled it when it was denied, and they said, maybe you shouldn't have denied it. You're 57, which means you meet the light grid, means that even if you could do light work, assuming no transferable skills, you meet the grid. So the real question here is, does your past work generate either, 2 points. One is, as performed, was it heavier than it's described? So let's say that, like I had at one of my hearings yesterday, my client was a truck driver. That is a medium job, according to the DOT, the Dictionary of Occupational Titles. Medium means standing and walking 6 hours, lifting up to 50 pounds occasionally, 25 pounds frequently. He had up to 100 pounds occasionally. So as performed, his job was performed at the heavy exertional level. So in a hypothetical question, when the judge is asking about past work, as it was performed, it was being done in heavy. And even if he could do medium work, he would not be able to do past work. No transferable skills, he meets the grid. So it can make a real difference. That's why they're asking all those questions. So, the more physical demanding the job was, that's going to make it easier for you to win. And maybe this is a situation where either A, the state agency identified the wrong DOT code, maybe it was something different than what you did, or it was a combination job where you had 2 or 3 different things you did, and therefore in a past work analysis, they've got to find the most strenuous level that you've got to be able to do, because they're looking at what you actually did. Or maybe there's some question about what the way you did the job and what the requirements were. On the other hand, if you picked up transferable skills, that works against you. So again, tell the truth, but that's what they're doing. They're looking at your past work really to determine grid rule and transferable skills. Nick says, hello to Nick. Could I give you some advice, please? I would be happy to give you some advice, to the extent that I can't give you legal advice about your case, but I can give you observations here. Okay. You're currently going through federal court, and Social Security is denying any wrongdoing because I found an error the ALJ made. But I found he cited a page that does not exist in the record. Would any lawyer take my case at federal court? Maybe. And again, I'll give you the same offer. Email me, jonathan@ssdanswers.com. I'll give you the name of some federal court lawyers who you can talk to about that. The question is, it's the wrong, page. doesn't matter. Doesn't matter. If the reference was to the wrong page, but the conclusion was the doctor said that you could lift 50 pounds, let's say, and it was on page 37, and the judge mistyped it, or the writer mistyped it as page 47. Okay, it's the wrong page, but the content, the reference to the how much you could lift is correct. It was just they call Scrivener's error. It's just a typographical error, probably not reversible. Now, I had an interesting case to give you an idea when I think when it would be reversible, and I haven't gotten a decision on this case. I had a hearing before a judge who's, it was decent approval rate, but kind of an interesting guy, does things very differently than other judges. Vocational witness was not impressive, been in front of this person before. And she referenced, he had asked for jobs, and she referenced a DOT code and identified a job. Well, the DOT code she referenced is wrong. I looked it up. I mean, she referenced, 358, it's 348. And I think that could be reversible error, because we don't know, did she mean 358 or did she mean 348? And the job she just, we don't know where the error was. So if this case gets denied for one, among other reasons, I'm going to argue that the vocational witness, and she also did not answer a lot of questions about, I think that they were very relevant to, in terms of absences, in terms of time off task, things like that. She didn't answer them very intelligently, I don't think. But I mean, she gave us, garbage when it came to the DOT code. I think that could be reversible. It's a little different than the wrong page, because she's citing something of substance. But I think the real question here is, if you talk to somebody who does federal court work, the question to ask is there enough there? Is that going to be enough to get you remanded? Because again, if the judge reaches the same conclusion but uses the right page number, you've gone through a lot of effort for no reason. So that's what I would tell you. So I don't know if somebody would take it. It's just going to come down to talking to different people. There are normally challenges of vocational expert, standard challenges to the supposed data. This is an evolving area. And what's going on in hearings now is judges are asking vocational witness to describe their methodology, how they came up with numbers. And there's a ruling, a Social Security ruling, that it basically says that the vocational witnesses have to do this. And I'll give you an example of where I think there's a problem with the way they do it. Is up until a few years ago, Social Security used something called the Dictionary of Occupational Titles. You can see it at occupationalinfo.org, and they still use it. The problem is the DOT was last updated in the 1990s. It's way, way outdated. So you may have a DOT code for we mentioned truck driver. So you type into the DOT truck driver, it gives you a code, 111 123 456 789. Okay. But the current way that jobs are identified, they use selected occupational characteristics. It's different resources, like apples and oranges. And there may be in a SOC code, selected occupational characteristics, there may be 10 DOT codes. So the question is, when you're estimating job numbers, okay, and you have a DOT code for a truck driver, but there's 10 DOT codes in this one SOC code, how do you know? And we know that there's, in the SOC code, which is more recent, there's 100,000 jobs in this selected occupational characteristics category. And we know that truck driver is 1 out of 10. Does that mean that 10% of that total number are truck drivers? What if 90% were truck drivers and 10% was spread out over the other 9 DOT codes? What if the other way around? What if there are 9 DOT codes that make up 98% of the jobs and the truck driver is only 2%? So it is inherently flawed to simply divide by the number of DOT codes in the SOC category. I realize I'm getting kind of in the weeds here. My point is, nobody knows how many jobs there are of any particular type of job. But now you're taking one series of numbers, the DOT, or of categories, and you're superimposing it on a completely different set that is not one-to-one. It's not one SOC code to one DOT code. Maybe, like I said, 5 or 10 DOT codes in one SOC code, because the SOC codes, there are many jobs in the DOT have been combined. They're just, they're not separated out anymore. My point here is that you could argue, when the judge asks the vocational witness, how do you figure in, or how do you calculate the number of jobs? They'll go through this math. Well, I just divide it by the number. Well, you can't do that. And I know attorneys who will, ask them and say, well, and just like I said, well, isn't it possible that, in this scenario that, you're dividing by 10, but it should really be divided by 75, which gives us a much lower number. My point here is you could go down the rabbit hole. Judges don't like that, because, their feeling is that, we all know there's no way to know exactly how many jobs that exist in the economy. And, some appeals counsel will go with that argument. Others will not. Some district courts will, some won't. It just depends on how aggressive you want to be. I play it by ear. I mean, I think, like, I had a case, like I mentioned the other day, where the vocational witness was just, I would ask a question like, well, if a person is, sick, I can't remember what the exact facts were, but if the person is, sick for 3 hours a day, 4 days a week, what is the meaning of that? Is that without a law for competitive employment? Well, I don't know. Maybe. I mean, she couldn't answer. That to me is, and I'm like, well, how can you're a vocational witness. You're supposed to know what employers will tolerate. So you're telling me you can't give me an answer as to, unexcused absences? No, okay. And that, again, would be an appealable thing, where I could say that the vocational expert did not testify with any expertise. So yeah, you can be somewhat aggressive there. Again, the Larry Rolfing School, and Larry Rolfing is a very well-respected disability attorney. You go to his blog, I think it's called California Social Security Disability Attorney. He is known in the community for being extremely diligent and extremely aggressive in going after vocational witnesses. His feeling is that they're all guessing. I'm not quite at that point, but I do see why he would say that. It really comes down to, I want to win, and I'm not trying to make law. And at some point, Social Security is going to decide that the vocational witnesses are giving enough information for us to feel like they can justify their answers, and that's still being worked out, exactly what that all means. But at the end of the day, if you get an appeal and you appeal the case and it's remanded because a vocational witness, did not land on Social Security's quote unquote approved methodology, you're rearranging deck chairs on the Titanic is what you're doing. It's going to get denied again. I'd rather have a good case that's going to get approved, as opposed to arguing about job numbers, in some esoteric, potential job, because again, the jobs they give are representative samples. So the answer to your question is, I sometimes will be a little more aggressive, but generally I don't typically go that route. I'm trying to win my case without even getting to that point. I want the evidence to be strong enough where a judge is just going to approve it because it's a really, really strong case, as opposed to going after the technicalities that may get me a remand, but probably won't get me a win. And life is too short. So that is my answer to that question. Jeff says, hope the new grandbaby. Yes, I just saw him a couple of hours ago. He doesn't do a whole lot right now. He's just kind of sleeping. Eating, sleeping, and pooping is mostly what he does. Does some crying too. But he's holding this, actually moving his head a little bit. I mean, they felt like the doctors felt like he, went through all the testing they give him, that he was very strong, eating very well. Everything's moving through him. So, I think, as my daughter so eloquently put it, he'll be a potato for the first 6 months. They don't do a whole lot the first 6 months, but, after they get 5, 6, 7 months, they start to interact with you a little bit more. And then by the time they start rolling over, and by the time they're a year, they're starting to toddle around a little bit. And then the next thing you know, like when my granddaughter started walking, then it just seems like a lot of things kind of, she became a lot more verbal. A lot of things really changed. And that was at about 13, 14 months. So now she's like a little person. and very opinionated. So, okay. DG's lives in the Charleston area, and and yet there is one judge there who is, I think, 12%. I had her one time. There's one judge at 80, but I think you've got one judge at 12%. Just ridiculous. I don't have any idea why. I think she's in Charleston. Let me just double check that because I don't want to tell you wrong. Yeah, I'm just looking at this. There's websites you can go to that will tell you what this. Oh, it's not working right now. Oh, there we go. Huh. Interesting. All right, that's not working, Judge. Let's try a different one here. And just so I don't know why, it doesn't really matter, but let's just see. Yes, this particular judge in Charleston, 14%, which nationally the approval rate's about 50%. My opinion is that if a judge is at 14%, 20%, 22%, they're so far below the standard deviation that there's inherently a problem. Social Security won't take any action on these judges, but, look, I understand some judges are going to be, 45%, 43%. They're going to want to see more than, they're going to see a certain amount of evidence. 50% is the average. But how could a judge pays 12% be fair? You can't. And, this judge, I had a case with her. Of course, she denied it. I'm appealing it. I had talked to one attorney colleague in Charleston, said, I've been doing this for 15 years, never won a case with this judge. Well, that's wrong. That's wrong. But we don't have any recourse. This is the problem. We have no recourse. All right, Rodney asks, does Social Security take long-term disability into consideration when making decisions? I think what you're getting at, Rodney, is the Social Security, if they know you're getting VA benefits or long-term disability, they look at it and say, well, you're already getting money. You don't need our money too. They're not supposed to. And I don't know that they do. I don't think that they do. I've never gotten the sense that a judge would do that. So I think the answer there would be no. I think, long-term, because realize long-term disability in particular, they offset. So if you get, let's say you're getting $1,500 from long-term and you get $1,200 from Social Security, long-term will start paying you $300 to make up the difference. And the $1,200 that you're getting from Social Security offsets what long-term pays you. So you're not really double dipping. VA, if anything, would be you can double dip, but for long-term, no. But my answer to that would be no, Rodney. And Naisha says, to clarify, it's okay to the same part-time. Yes, it doesn't matter what state you're in. The SGA and trial work period numbers are the same, no matter what state you're in. Like I said, the biggest thing you want to keep your eye on is the 3 paycheck months. So the 92, that is correct. Well, let me put it this way. Answer is generally yes. I mean, what I use the form 1693, which is Social Security's official form. It covers work through the hearing stage. Beyond that, you would enter the same form. It's just check a different box. That would basically mean that, the attorney can ask for what are called 406B fees. Still have to be approved by a judge, but it's basically going to be 25% with no cap. Because again, it's a federal court action, and they recognize that, federal court, then it comes back to the hearing. So realize you're not paying double, you're paying 25% for both the hearing and realize you've already gone to one hearing, you're going to appeals counsel, you're going to federal court, going back to another hearing. So now you've been at 3, 4, 5 hearings, or procedures. So they take the $9,200 cap off. That is correct. And 406B fees. That's the way. And honestly, the way I do it is for federal court, I will co-counsel with Carl Osterhout or Brian Konoski, somebody like that. And then when we get the 406B fees, we work out a split. Because we'll have done 2 hearings in an appeals counsel brief, and they've done the federal court work. And so we work out a deal just because obviously put a lot of work into it. So, but yes, but I think it's important to let people know, let our clients know at the outset, yes, there's no $9,200 cap when it goes to federal court. Barbara Gillespie is a widow, 59 years old, applied for SSDI in November of 25. That they've received everything they need. They'll make a determination. Do you think you are in good shape? You're denied. Said it doesn't mean it's a bad thing. Again, 59 is always going to be helpful. You could also, by the way, if you maybe you're alluding to this, but did you apply for disabled widows benefits on maybe an ex-spouse's earnings record, which may be higher than your earnings record? So I'm not sure if that's why you put the widow part in, but there is something called the DIWB, Disabled Widows Benefits. But anybody who's 59, you have a real advantage. You have the grid rules. And, even if you could do light work, assuming you have no transferable skills and you've got physical limitations, I win a lot of cases, I will tell you, and I keep track of this. Grid rule 202.06. I win a lot of cases on that one because it's for people over 55, no transferable skills or no past work, and they're limited to light work. You win. And light work, realizes lifting 20 pounds occasionally, standing and walking 6 hours a day. That's pretty common. So even if you could do that, you're still disabled. It's a really, really powerful tool. And they were trying to take it away, but they didn't take it away. So that was good. Okay. If you start, I did, Sarah, but to answer it again, if you started over again, start a new application, my belief is the attorney would not need to waive fees. If you want to be safe, ask the old attorney to file or to give you a form 1696 SUP SUP2. 1696 SUP2. That way you've got it in your back pocket if there's a problem. I would say if you got a new attorney, make sure he or she will know, let them know you have a prior attorney in a previous case, and they can make a decision whether they want to get a waiver of fees. But I think it's a new case. I don't think that, you would need to get fees waived because this attorney did not represent you in the current case. So my opinion would be no. Thank you very much. You're welcome very much. I enjoy this. Actually, I learn from these because, people ask questions I never would have thought of, and I find it really interesting. And, I've had a number of guests on. I've got more coming. In fact, I was talking to another colleague the other day, and I was like, come on to the live stream. Well, I don't know. Yeah, it's actually fun. You get to answer questions in real time and talk to some really nice people, and you kind of hone your skills, I think. Yeah, Michael, you were the one I think was asking about the forms. Yeah, I'd print it out. Absolutely. And again, you can, if you're typing things, but it's better to type than handwrite, I would say. You're welcome very much. Okay. Good evening. My SSA site, I guess you're my SSA, my Social Security Disability, or my Social Security site, said a representative of Baltimore started a final review to make sure you meet the non-medical requirements for disability. So generally, today made a decision to deny application, 61, 38 years. Should I appeal on the grid rules, cervical spinal stenosis, carpal tunnel? I think so. I mean, I think you appeal. Realize that when you, and Kathy, because you had said before here that I said on the 24th, they started a review and they denied you. So just because they started a non-medical review doesn't mean they're going to approve you or deny you, as you saw. When you argue for disability, when I'm writing a brief, I'm going to always, if it's a grid rule case, like say in your case, you're 50, you're 61, 38 years in the same job. So I would argue probably if you've got, physical problems, cervical stenosis, carpal tunnel, lesions on the ulnar nerve, I'm surprised they denied you at 61. That doesn't make any sense to me because I think that you've got, I don't see how they could conclude you could do light work. Because again, at 61 with all these issues, light work is lifting 20 pounds occasionally. I just think that's bogus in my view. I think you have a winning case in my opinion, based on just what I'm seeing here. I would take that case in a heartbeat. But I think that they've obviously found that you can do light work. Since they found you can do light work and your past work probably was light, they don't go any further than that. The grid rule, realize, and I don't want to make this overly complicated because it's Social Security, they make everything simple confusing. There's a 5-step sequential evaluation process they go through. Step 1 is, are you working? Okay, you're not working. Step 2, do you have a severe impairment? Well, again, if it's diagnosed and, cervical stenosis is going to be severe, carpal tunnel will be severe. It has some effect on your functioning, okay? 3, do you meet a listing? Most people don't meet a listing for many reasons. We'll just leave that where it is. Step 4, can you return to your past work? If they found you could, they stop and say, we're not going to go any further. If they found you could not go to your past work, then they got to go and say, could you do other work? And that's where the grid rules come in. So you've got to get past step 4, saying you could not do your past work. And, that's where I think they've made a mistake in that, I don't know what you did, but you did it for a long time. And I think any job out there, if you've got severe stenosis, carpal tunnel, lesions on the ulnar nerve, it's going to be hard to do many jobs reliably. So I think I would attack it as a functional capacity issue. Let's get through step 4. You can't return to past work. And we can continue on and say that the combined effect of all your problems would make you so unreliable that you'd miss 2 days of work a month. You'd be off task 15%. That's the functional capacity argument. In the alternative, we're saying we can't do past work. Grid Rule 202.06 applies. Okay. In the alternative, argument number 3 is there is an enhanced standard of evaluating transferability of skills because you're 60. If you're limited to light work, you've got to show that there'd be minimal vocational adjustment for any transferability of skills. Again, now we're still in the grid rule argument, but it makes the grid rules even stronger for you. So that's a third kind of argument there. A fourth argument is you've done the same job for 38 years. If it's arduous, if it's physical, you've got this POMS regulation I talked about earlier. So I can see 4 or 5 arguments that you could make, which tells me, again, I've done this for a long time, 35 something years. You got a winning case. I think you have a winning case, unless the evidence of your cervical stenosis and carpal tunnel show just extremely mild limitations. There's really nothing there. The lesions on the ulnar nerve are not symptomatic. I just think that, based on what I know and what I've seen, I think that this is a winning case. That's my take on it. Good evening. Okay, Heather Rash, you were on Steph's. I'm not sure, were you on Steph's live or were you when Steph was here? Because Stephanie Joy comes on my live and I've gone to hers a couple of times. I'm not sure which one you're talking about, but either way, it doesn't matter. Okay, you're 39, had brain surgery to partially remove a brain tumor involving the carotid artery, the optic nerve, and other structures. Followed SSDI in August of 24, currently in recon, Rec 5 irradiation. Now have a neurological exam. Do you have any suggestions? Anything you should be prepared for? Unfortunately, brain does not work the way it did. Okay. I would say, if you have your medical records, they're sending you to a neurological exam. If you have your medical records discussing the surgery and the post-surgical treatment, I would bring it. They don't have to read it, but I would make a copy of it and leave it with the doctor and just say, this is, in order for you to understand what I'm going through, this is what I've got. All right, that's number 1. Number 2 is I would sit down with a friend or a family member and write out those things that you can't do anymore, whether it's physical things like standing and balance and things like that, or it's cognitive. You can't remember, you have emotional instability, anger control, crying spells, whatever it may be, and sit with somebody and make a list of those things and bring it with you to the appointment and say, these are things I can't do. And in preparing for this, I want to be able to give you accurate information. Yeah, I prepared for it. I wrote this stuff down, and leave it with them. Number 3, make sure somebody comes with you. A lot of times they'll do a collateral, they call it a collateral source, interview with somebody who's there with you, or you could have somebody you could ask, can this person sit in on my appointment? Maybe not to say anything, but just to take notes if you can't. So I think it's just, really want to focus on the functional issues, whether it's physical or it's cognitive or it's emotional, social, whatever the issues may be. You want to make sure you write them out and you give it to the doctor so that they know what's going on, and it'll be in the report, that Heather gave me this information. And the reason Heather gave it to you is because she can't remember very well, or she, gets nervous and gets very anxious when she gets nervous. And so that's why she did it. It's nothing, you don't have to apologize for that. And I think, the goal is to get accurate information, bring the doctor your medical reports, make notes about what what the issues you've got, and hand it to the doctor, answer the questions as best you can. But I think all that's very, very relevant. So yeah, I wish you the best. I hope that that does work out. R. Willie, how important would a 100% mental health rating and DBQ evidence have I filed for SSDI? Again, you're talking about VA. Social Security is not bound by the VA findings. I do think that the information in the DBQ is relevant. The 100% is not going to bind them, but presumably there's treatment that got you there. That's going to be relevant. You still have to focus on the functional issues. Now, I would agree, because you're probably thinking to yourself, you have Social Security, you have the VA. Why do they have two separate standards for disability? No answer to that. I can't tell you. It makes no sense to me either. But I think you got to really focus on the functional issues that got you there. If it's PTSD, if it's anxiety, depression, some organic schizophrenia, bipolar, whatever it may be, but you want to identify those things that make you less reliable because of all those things. And that's really what you got to focus on. All right. I was approved on December 5th, says Mr. Pet Mom 4. And still haven't received back pay. My attorney's been paid. I contacted my congressman. He says, when I hear something back, that's really all you can do. I mean, sometimes people don't get paid because there's an SSI component and they've got to go through the income and resource interview. Sometimes it's just red tape. I was just talking to my paralegal today. I have a case that judge approves it, but then denies my fee agreement because he said there was a prior attorney. Well, the prior attorney he withdrawn, that 6096 sub 2. I write the regional commissioner, like, look at the record. It's in the record. He withdrew. Regional commissioner writes the judge back, this approve the fee. Fee is hereby approved. Social Security then sends me half the money. We've been trying for 2 years, 3 years to get the other half. It's just, so red tape. Red tape is crazy. Crazy. Yeah, no, I'm sure you are losing patience. And again, I would just stay on your representative. Maybe they can, but this is all you can do. There's just not much you can do. It's the problem. William Hicks was in a car accident, traumatic leg injury, chronic lymphedema, which is swelling, which is very painful. And actually, I find it be very disabling. History of cellulitis, infection in the soft tissues. Best argument, you can work full-time. You cannot work full-time. Well, again, William, if you're over 50, you got the grid rules. At a minimum, you have a functional capacity argument where you say that the combined result, combined effect of these limitations would make me not reliable. And you can break them down one by one, no pun intended. Leg injury limits you standing and walking and sitting, because bending your leg to 5 minutes, 10 minutes, 15 feet, whatever it may be. That's going to limit you there. Climbing ladders, ropes, and scaffolds, can't do it because of the leg injury. Kneeling, crouching, stooping, balancing, crawling, can't do it because of the leg injury. Can't get off the floor. That's going to eliminate categories of jobs. Lymphedema is going to be painful. It's going to be difficult to perhaps hold on to things. Look at each of those type of things. How does it affect you? The cellulitis, are you more subject to infections of different things? Are you contagious? Do you have a open wound? That means cannot be around hazardous or dusty or dangerous environments, or where you could get infected. Maybe you're susceptible to cold or heat, or again, respiratory irritants. I think each of these things, what are the problems that you've got? You need to lay down. That's a big one. If you have to lay down, I had my hearing the other day. One of my hearings clients like, yeah, I mean, I've got to lay down sometimes 2 hours in a day because the pain in my back is so bad. In order to get relief, I've got to take all the pressure off. Maybe the doctor wants you to keep your legs extended because of the blood circulation or fluid issue with the lymphedema. So everything you've got going on, look at the functional or practical limitations that arise from those things. Bad leg injury, walking, standing, stooping, crawling, crouching, all those kind of things. The lymphedema, maybe you need to have your legs, your arms raised. You have to maybe wear a compression hose. That could affect things in a job situation. Can't lift things. You can't afford to get cut. So again, hazards, things like that. Just everything you've got, figure out the functional issues that arise from it is what I would tell you to do. Okay. And having reached out an attorney. Yeah, again, being 39 definitely makes it more difficult. It definitely makes it more difficult. I would tell you, Heather, though, and, again, Stephanie, I know if you know Stephanie, reach out to her. If it's brain surgery, it's cognitive, if it's something that is not, physical, and I'll put depression, anxiety, PTSD in this category as well, age is not as much of a factor because, you can be 39 or 59, but if you've got, damage to your brain, organic damage because of the removal of a brain tumor and damage to other structures in the brain, it's left you with, inability to focus and concentrate or process things or move quickly, or your balance is off, or you get dizzy spells, or you're on medications, chemo agents for the rest of your life. It doesn't really matter how old you are. So I would be less concerned about a 39-year-old in those circumstances than I would be if it was a back and neck pain case. So yeah, I would probably tell you to reach out to an attorney. I think that's, if it's going to be a lot for you to handle on your own, that's when an attorney can really help take some of that burden off. Absolutely. Absolutely. Let's see what we got here. Okay. Racing Crazy. I was recently approved by old employer of 35 years, asking if you could work 6 hours a week for $200 with $800 a month trial. Well, again, it's less than, I think 1,200 is what we saw. Trial work period is like $1,200 a month. So it's less than trial work period. So as long as you're less than trial work period, to me, there's really no danger at all. I think when you're over trial work period, use them up, and you're getting close to SGA, now we're starting to get to a question of, is this going to look like you have capacity? But realize Social Security wants people to try to work. So if you're working at less than trial work period, $800 a month, or realize $200 a week, but if there's 5 weeks, it may be $1,000. So now you're getting a little bit closer. You got to really keep an eye on that. But let's say you're at $800, $900 a month. That's below trial work period. So I think that as long as you're below trial work period, I think that it's really not risky at all to work, because otherwise Social Security would have people not working at all. Why would you even try if it's going to be used against you? So I think, when you're below trial work period, I would not be concerned about that at all. And it'll be above board W-2. Yeah, that's fine. That's fine. I don't see it as a problem. At 51, does the grid impact you negatively? 70% mental health, 100% overall. Well, first of all, the grids only apply when you have physical limitations. They do not apply when you have mental health. So the grids don't even apply in that situation. At 51, though, you've got to be able to show you're limited to sedentary functional capacity. And where a lot of my 50 to 55-year-old clients get denied is the state agency says, well, you can do light work. In that situation, the grids say you're not disabled. If you can, if you're 50 and you can do light work, you're not going to be disabled. So you really got to go for, either a functional capacity argument or argue that you're limited to sedentary work. So to the extent that, a light RFC, or residual functional capacity, is going to not allow you to get approved, yes, the grid would be used against you. But again, the grids are designed to help Social Security find people approved, but it's just a framework. So it's not really a positive or negative, it's just a framework. But the framework at age 50, if you're limited to light RFC, is going to you're going to be found not disabled based on that. So you would need another argument to win, either a sedentary grid or functional capacity, in order to win. Okay. I've sent in my bills and everything I can't afford. Is there a chance of my overpayment? Never had that kind of debt. Let's see here. Have you ever gotten overpayments waived in the past? I've used that, and what you're talking about, there is a form you can fill out to ask for a waiver of overpayment. I've had them reduced. I've never had them completely waived. So, you could try that. I would also tell you could bankrupt on it. I mean, people don't realize that you could bankrupt. If you qualify for a Chapter 7, and you might want to look into that, bankrupt on it. It's dischargeable in bankruptcy. There's no fraud. You can discharge it in bankruptcy. So I would look at that option as well. But if you can argue, you would argue to them that you simply cannot afford to pay this back. But it's all within discretion. Sometimes they go with it, sometimes they don't. They may waive some of it. They may say, we'll waive $40,000, but you still owe us $20,000, which may not help you at all. But again, maybe the payment plan would be a little more viable. But yeah, it's very tough when you're that far behind. Okay. So Rob is, I'm 51, initial application denied for light work, like we talked about. That's when you ask the grid. That's why the grid impacted you negatively. 100% VA, 70% mental health, cervical, I guess it's the cervical spine with degenerative arthritis, disc syndrome, spinal stenosis. And again, these are all diagnoses. The question is, what do they mean in terms of your functioning, your lifting, your carrying, your standing, your walking? So the diagnosis doesn't win your case. It's the practical impact of it. That's what you want to really focus on. But yeah, I mean, I think that, you would argue for the sedentary grid or just an overall functional capacity argument. If you do light work part-time and don't meet SGA, do you hinder a sedentary finding? No. If you work part-time and sedentary, do you have transferable skills? No, I don't think so. I think that let's break this. That's a very good question. You asked a very smart. Those are very sophisticated questions. I compliment you on that. These are not questions yet that a lot of people would even know to ask. But good for you. A great question. So if you do light work part time, basically means you're not able to do it full time. So SGA assumes that it's substantial. If you're under substantial, if you're not making enough to be SGA 1690, it's not substantial. So, that does not mean you could do sedentary work. It's not evidence that you could or couldn't. So, no, it does not. It just means that you do part-time light work, but there's no process in the Social Security world that says part-time light work equals full-time sedentary work. So, no, there's no relation whatsoever. You still have to prove you're limited to sedentary work. But the fact that you could do light work part-time, it's evidence of some capacity, but there's no one-to-one correlation. Now, you might get asked, why are you part-time? And I've seen judges kind of go down that rabbit hole saying, well, you're part-time because, you chose to be part-time or because there's only part-time available. But if you were full-time, could you do this job full-time? And, you need to be able to show why you couldn't. That this is the most you could do. But no, there's no, part-time light work does not mean full-time sedentary because, is it, 2 hours a week or is it 12 or 15 hours a week? It's just, there's no relationship there. They're going to look at what you can do, but there's no definitive relationship. As far as part-time sedentary work, generating transferable skills, I think that to get transferable skills, generally you have to have worked at a job at SGA level for a certain period of time. And for semi-skilled, and I don't remember what exactly it is, maybe 0 to 6 months. At for a skilled job, it's maybe 6 months to 2 years. And a vocational witness can testify about that. But I think if it's working part-time, the assumption is you're not working long enough to acquire all the skills that you would need to do that job full-time. You're only doing it part-time. The presumption is that a part-time worker may not be given all the duties of a full-time worker. So the answer to that question is, I don't think there'd be transferable skills that would arise. Now, I haven't thought about this, but let's say you did part-time work for 15 years for a company. Could Social Security argue that you've acquired transferable skills because of the long duration of your part-time work? Maybe, but I still come back to part-time work does not give you exposure to all the obligations and duties of the job. Therefore, you couldn't get transferable skills. I think it would be a really hard argument for Social Security to make. So I'm not saying it's impossible, but I would say, generally speaking, that's how I would counter it, by saying that part-time work does not, part-time workers are generally not given the same responsibilities or training as full-time workers. And secondly, working part-time, you're not going to be exposed to all elements of the job. So picking up transferable skills is going to take either a lot longer or not at all. But again, the open question in my mind is, if you did part-time work for 10 years, would that be enough? And I don't know. I would still think not, but that's a vocational witness question. But that's actually a really good question. In fact, I was going to reach out to a vocational witness I know. I may ask that person. That's a very good question. Let's see here. Okay, this is Heather says you just can't seem to focus on your recovery because you're dealing with the whole process. Yeah, I hear you. I mean, it's very confusing, and it's designed to kind of intimidate you to some degree. And you'd like to go back to work, but just right now you got a little recovery. You got to focus on your recovery. That's exactly right. So that's what you should focus on. And I would tell you to get a lawyer. Cynthia, you're welcome. Thank you very much. I appreciate it. Thank you. They are a blessing. Doesn't mean they don't drive you crazy sometimes, but they are a blessing. Okay. With most attorneys taking only case they think they can win, how much do they actually win? Again, I think everybody's got different thresholds. I tend to be, and again, I've discussed this before. We only get paid if we win. So obviously I can't stay in business if I'm taking, marginal cases, people that are 28 years old with a mild bulging disc and mild carpal tunnel. I just know those cases are not going to get approved. My philosophy is that, most of the cases I take are people over 50, even, or 55, even better, with something pretty significant. These are cases I think I've got a good chance at winning because I got the lights to keep on. I got staff to pay. I will take every month one or two that are a little more questionable, a 45-year-old, a 35-year-old like Heather, who's got a really significant problem. And I'll give those a shot. And sometimes I win and sometimes I don't. I think that, I've got a pretty good eye for it. And, notwithstanding the judges that approve 12% that aren't going to approve anybody, I think for me, being in the 90+% of approval is kind of where I want to be. But I'm very selective and I take good cases. And honestly, the medical is more important than, I always tell people this. I joke around with my clients sometimes, and I'm not really joking around. Whether you win or lose is about 85% of the medical record. It's about 10% of your testimony, and it's about 5% of your lawyer organizing things and making the argument ahead of time. Maybe a little more with a good brief, but a good case is a good case. And as a judge said to me, actually this was pretty funny. One of my cases yesterday, it was going pretty well, but the judge, what she did was she went, I wrote a very compelling brief, I thought. She opens the hearing, goes right to the vocational witness and asks questions. And essentially, appeared to me was recognized that the grid rule applied. No transferable skills, person is limited to light work, no transferable skills, or whatever it was, and she was over 55. And the judge says, any questions? And of course, nothing, no testimony, no anything. So my general practice is to say, I want to ask at least one question about off-task behavior or missing work, just so I've got it on the record. So I said, well, Judge, in the interest of completeness, I'd like to ask a question about off-task behavior and missed work, time from work. And she said, Mr. Ginsberg, have you heard the expression, never pull defeat from the jaws of victory? Yes, I've heard that expression, and that means that a smart lawyer knows when to keep his mouth shut. So I just said, okay, then I have no questions. I just kind of laughed, but I had no questions. We're going to win that case, but I don't like when judges do that, because if the judge denies the case and I didn't ask any questions at all, my argument would be, well, the judge implied she was going to approve the case. Is the appeals counsel going to go with that? I think that anybody listening to that or that audio would come to the same conclusion I was. She's basically saying, I'm going to prove the case. By saying to me, don't pull defeat from the jaws of victory, she's telling me I've won, right? So I think we're going to be okay. I know we're going to be okay on this one. But, sometimes you got to, you don't know what the judge is thinking. And the judge, may be thinking, well, I've signaled every way I possibly can that this case is going to get approved, yet why is the stupid attorney asking questions? Well, because I didn't pick up on your signals, and I got to cover my behind and my client's behind. So I'm going to ask questions. I'd rather, just ask a few questions just to say that I at least inquired of this so that it's on the record. But, I would say, when I finish a hearing, I write down my notes, what I think happened. I'm right about 85 to 90% of the time. And the times I'm not right, I'm usually surprised in a positive way. I didn't think it went as well. We got approved. Every once in a while, I get a surprise. So the answer to your question is, if you're only taking cases you think you can win, what is your standard? If you have a very high standard, you should be winning 90-something% of your cases. If you're taking cases that are more challenging, you may win 75%, 80%, but that's not the lawyer's fault. I think it's just a matter of what you take. Look, there are lawyers I know who do this kind of work that are barely scraping by. They're taking cases, that aren't that good. And if they don't have a good marketing department, they're not going to get very good cases. I will tell you, when I was taking cases only in the Atlanta area, I might only take 1 or 2 cases a month. Now, because I can do it nationally, I can take 15 to 20 a month that are pretty good cases. So, it's just going to come down to, what a lawyer's standard is and what they think they can win and their experience with it. And again, I just know that, if you're under 50, you got to have a really, really high level of evidence. If you're over 55, you got that grid rule. You got a pretty good shot at it. That's why this person who was 59, I'm like, who are 61 with all these medical, physical and nerve problems, those are winning cases. That's my AI, not artificial. It's I just know. So that's how I'd answer that question. It's just going to depend on the threshold the attorney has for risk. What about a person who has ulcerative colitis in their colon? Again, Albert, that is a diagnosis. And I think I win a lot of cases on colitis because a person who has to use the bathroom 3 times an hour is not going to be reliable enough to sustain work. But you need evidence to show that the colitis is symptomatic and that they are going to the bathroom, a unacceptable number of times during the day. And literally, I tell my clients, keep a calendar with every time you had to go to the bathroom. And you need medical support. The doctors tried different medications, has not worked. You've undergone surgery, perhaps, to have some of your colon removed. The colonoscopy shows lesions, active colitis. So, I think that if you've got good evidence and you've got evidence of missing time from work, I win those cases 7 days a week because, that's the issue in a disability case is reliability. I've had a couple where the colitis was really mild or not symptomatic. There was no active disease. It doesn't, the person's saying I'm going to the bathroom 10 times a day doesn't line up. So, it's got to be consistent with the level of disease you've got. Okay, so Heather was saying Stephanie does her live on Wednesdays, I think at noon. And if you don't know her, Stephanie Joy, Joy, is a good friend of mine, and she does live streaming on Wednesday afternoons, I think for about an hour at lunchtime. And I've been on hers once or twice, and she's been on mine like 3 or 4 times. But we chat a good bit, and we kind of compare notes, and we're talking about AI and all that stuff. But the nice thing about this practice area is there are a lot of attorneys who are willing to share what they know, and we talk, and there's a listserv where people talk about judges and different strategies and things like that. So it's a very pleasant area of practice. I know that when I did other kinds of work, domestic relations or even personal injury, it's not quite as pleasant. Domestic, you don't want to be seen fraternizing with the enemy. So, you may have, you may know the other attorney, but you can't really have a nice chat with them because your client's glaring at you. Why are you talking nice to my witch of a ex-wife's, or soon to be ex-wife's attorney? Workers' comp, the clients think you're colluding with the other side. And so, I think, in my opinion, a good attorney can sort of separate the argument from the personality. Domestic attorneys, maybe not as much. That they tend to take a little more personal. But so I've been in bankruptcy cases where I'll go to lunch with the opposing counsel, and we have a case, we have our jobs to do, we make our arguments, but it's not personal. And this obviously is not really a personal thing either. You have a lot of attorneys trying to get the same thing, and we're all trying to learn from each other. And again, there's enough good cases out there for everybody. So, I think that's why I do bring other people on here, because, we all can learn from each other, just like I'm learning from you guys as well. Okay. Now, R. Wiley, you've asked a very, very interesting question. Again, commend you on it, because, you're thinking outside the box, which I think is a smart thing to do. He's asked Grok, which is I think that's the Meta or Facebook artificial intelligence engine, to analyze your DBQ, your disability benefits questionnaire from your VA claim. And it says you meet listing 1204 A, B, or C. I would say this: artificial intelligence, and I use, and by the way, you have to be very careful about using these, because not all of them give you confidentiality. The one I use is Notebook LM, the paid version, which is a closed system. They call it a RAG. It only considers what you give it. It doesn't go outside, doesn't share information. You turned off the sharing part of it and all that stuff. Or you could give facts to another one, Claude or Perplexity. I think that a lot of these AI tools are not, they don't have enough data to really make decisions about Social Security. I mean, it's hard to meet a listing, and they may say that there's a listing argument there, but again, I haven't looked at your record, but I think that's, I don't buy it. I think that, I don't ever ask an artificial intelligence tool to tell me if it's a winning case or not. I'm going to ask it to summarize evidence, to draft a brief under my specifications. But, most of them are programmed. I forget the term. It's like syncopathic or syncopathic, I think. Basically, it means that they want to please you. They want to tell you what you want to hear. ChatGPT is known for this. You'll ask it a question. Oh, that's a great question. They're kind of brown-nosing you a little bit. And I don't know Grok, because I've never used it, but I think a lot of them have that kind of built in, that they want to compliment the person. And so they're telling you information that is really optimistic. At the very least, I would say maybe run it through and realize the DBQ is only one part of the evidence you've got. There's other actual evidence. And so, what I would do, if you're comfortable with the security part of it and the privacy part of it, get onto Claude or Perplexity or even ChatGPT, upload your entire file. What are the arguments that would apply here to help me win disability? And what are the odds of each one? That's the way I'd ask it. But I just think to ask Grok based on one piece of evidence, No, I don't buy it. I just don't think that you're going to get accurate information there. And you just got to be very careful with the privacy part. Yeah, check with her. I've not heard that from her, but definitely check with her. If she's not taking them, call me. But yeah, I mean, you've already kind of reached out to her, but yeah, I don't know that that's the case, but check with her again. Okay, how do you appeal a denial of SSA states that you can't do your past sedentary work, but there is other work you could do? What's less demanding than sedentary? It's not, I mean, it can be, you could have a sedentary skilled job that you couldn't do. So you might be, let's say computer programming might be a sedentary skilled job that you could do a sedentary unskilled job like data entry. That's what they're saying. So it's not that you're not able to do sedentary. They're saying you can't do your past work, but it's probably not on the sedentary part. It's on the mental part of it. It's on the skilled part of it. So you've got to get rid of those skills. And the way to do that would be to focus on pain or other non-exertional impairments, severe pain, poor sleep, medication side effects, depression, anxiety, things like that would reduce the transferability of skills. And that's the way you get past it. Corleone Sports. My takeaway was 41,000, 10,000 to attorney. I have one son under 18. That was 24,000, 66,000 total. I'm not sure what you're getting me at there, Corleone Sports. Are you saying that what you were, I don't understand it. I apologize. I'm not sure. Maybe you could clarify for me. I have a judge that's 30%. Not great. I mean, I much prefer judges in the mid to high 40s or higher. 30% is low. Although one of my hearings yesterday, this is the judge that asked only one couple of questions of the VE and nothing of the claimant, 33% judge. I've won 2 cases in front of her. So, but 30% is low. 30% is low. Okay. What does it mean when they say, Ann says, you can't lift more than 10 pounds, but you can stand for 6 hours? Is that a light? Well, again, light work is defined as lifting 10 pounds frequently, 20 pounds on occasion. If you're limited to 10 pounds occasionally, then you're a sedentary RFC. You're a reduced range of light. 6 hours standing is a light. So that says to me, if you're limited to 10 pounds occasionally, but standing and walking 6 hours, that is a reduced range of light work. So you could not do light work, by definition, is defined as lifting 20 pounds on occasion, standing 6 hours. Now, if a vocational witness said, well, there are light jobs that don't require lifting, the light part of it is based on the standing and walking, I guess theoretically, Social Security could argue that you could do that particular light job. But I think that the argument I would make would be that that's probably within that job description. It's only a small percentage of jobs wouldn't require the full obligation. And again, if it's described as light, by definition, you have to have the capacity to lift 20 pounds occasionally. So what I would come down on this would be, you have less than a light RFC. You are at a reduced range of light or a sedentary RFC. You can do more standing than sedentary requires, but your lifting limits you. Again, my case the other day, and this is a case with the truck driver, very little medical evidence. There was one consultative evaluation in the file, and the consultative doctor said he could lift 50 pounds. Not good. But it also said he could only stand 4 hours a day. The judge asked a hypothetical question. If our hypothetical person is limited to a medium RFC, but can only stand 4 hours a day, would that allow for medium work? The answer is no. Medium work, by definition, requires you to stand 6 hours a day. So getting back to this other question, or your question that you just asked, if you can't fulfill the full obligation of a light job by standing or lifting 20 pounds on occasion, all light jobs are precluded. That's my take on it. You'll in the Philippines. Imagine the fun on 60 pesos to the dollar. Okay. Actually, I have someone who does some work for me in the Philippines, does some video editing, and she'll probably be watching this. So if you run into Corleone Sports, you'll know that was for my live stream. Chloe is my person in the Philippines. So, but I don't know what 60 pesos would buy you. So can't answer that. Okay, you got a favorable report. Yeah, no, Kathy, you have a winning case. You have a winning case, I think. Thank you very much. I appreciate it. And he's doing good right now. So he's, like I said, doing everything he's supposed to be doing, which is eating, pooping, and screaming. If you're doing a new claim with 3 new severe impairments, sleep apnea, stroke, severe arthritis, and turning 50, you think you'll be approved. I think that turning 50 helps you. The sleep apnea is non-exertional, means you don't feel rested. A stroke in the right eye of loss of vision, that's a non-exertional, although again, depth perception is going to eliminate jobs that require you to drive or to depth perception or ladders, ropes, scaffolds, unprotected heights. Then the arthritis in your right thumb may limit you lifting wise. So I think at 50, I would make a grid rule argument, 201.06, and say I'm limited to sedentary work, but I can't do past work. There's no transferable skill. Excuse me. And at 50, that would apply, and or my functional capacity is so reduced by all these things, non-restorative sleep, can't see, binocular vision, arthritis, can't lift things more than 5 pounds. You want to quantify that with your right dominant hand. That's the argument I would use. Larry, how you doing, Larry? One of my cases, we won. Had one of your Army buddies. Hope you can help him. I hope so too. Make sure to tell him to mention your name. So I will definitely reach out to him directly. But thank you, Larry. I appreciate that very much. Okay. All right. Now, Big Tie, you bring an interesting point up. So Big Tie is basically saying you're having a new claim with 3 new impairments, because remember we talked about the importance of having something new, which is important. You're turning 50, and you had a previous hearing determination limited to sedentary work. I would argue that, and there's law out there, and I forget the name of the case, but there's a case out there that says that, and I've used this before, you are found limited to sedentary work by a judge. A new judge can't come along and say you can do more than sedentary work. I think that's just like the, decision has been made on your prior disability claim. Those impairments before date of your decision, I think that, unless there's been some significant improvement, and things sounds like they've gotten worse, I think that the judge is going to be limited to finding you're limited to sedentary work. Now the only question is transferability of skills, and you meet the grid. So I think that works in your favor. But again, I did have a case like this, and the judge didn't go for it. I disagreed with him, but he didn't go for it. He said, well, I think that the person has improved because the prior determination was like 4 years prior. I think they've improved. I didn't, but, the judge didn't go for it. But there's a case that says that he was required to consider that, to give it a significant consideration. It doesn't say they have to find you limited to sedentary, but they've got to give it significant limitation. And they didn't do it. The judge didn't do it. So, never telling what, but I think it's certainly worth making that argument there, because again, it was found limited to sedentary before. What's with the payment centers? They're understaffed, and they don't care. It's not their money. I don't mean to be cynical, but they there's just not enough people at Social Security. Not enough people. Okay, so your DLI is December of 26. So that means that you can apply as long as your onset date's before, then you're fine. I'm sending in my VA mental health treatment. If you have more, look, the VA, I'll be honest with you, R. Wiley, VA mental health treatment usually consists of giving people a pocket full of drugs. And, a lot of my VA clients, if they took all the drugs they were prescribed, they would be the walking dead. They'd be zombies. I personally like to see something more than just VA records. Or if you're going to have VA records, they need to be long, 2-3 years of records. But I think you need to have, if you can get a private doctor to do an evaluation, that would be even better. Statements from former coworkers, non-medical statements. I will tell you from what judges have told me, and I know for myself, I get a VA file, client who's had VA treatment, only VA treatment. My average file is about 1,200, 1,500 pages. VA is going to be 3,000 or 4,000 pages. A lot of duplication, copies of copies of copies in there. Very hard to plow through. A lot of stuff that's not particularly relevant in there. And now with some AI tools, it's a little bit easier to work with, but I used to go through, I would go through 3,000 pages of record. And there may be, 600 pages of relevant material in there. Judges don't like it either because it's so much duplication. So anything you can get that kind of summarizes it, a synopsis of it, that would be helpful. Again, I use AI tools to do it. I've had judges, basically thank me for giving them a brief that summarized the evidence because they don't want to go through 4,000 pages of VA records. So I think just uploading it, it would be helpful to kind of summarize what it says and give kind of a narrative timeline. And that's a perfect job for AI tools, by the way. I use Notebook LM, and it does a really good job with that. Okay, so the ALJ in your past case says you're limited to sedentary, can't do past work. If you have no transferable skills, I think you are pretty good shape. Andrew, you were very welcome. Thank you. Thank you. Thanks for tuning in, and nice of you to say. I appreciate that. Okay. The ALJ made a normal gait. Okay, the ALJ made error saying I have a normal gait, but said there's response to a severe skin disease. The CE said mildly antalgic or limp. ALJ didn't mention orthopedic boot I was prescribed. Yeah, those are the sort of things that could be, if you have an orthopedic boot that you're using and the judge talks about a normal gait, I think you can make an argument that's an error of fact, that you, by definition, can't have a normal gait with a walking boot. And that could be grounds for appeal. I think it very much well could be. Absolutely. With federal CDRs and AI, how tempted are templated ROS entries weighed? If non-psych visits autofill, no anxiety for primary CFS, can that create? I would say this. AI is not yet fully at the federal level. They're starting to incorporate that. It's our reality. I mean, I think that, you have to be your own advocate. And that may mean you have to write the emails to the doctor, send faxes to the doctor, talking about things that didn't get in the record, ask the doctor to correct the record. If things are being auto-filled, ask the doctor not to auto-fill it, but you got to put it in writing. I think you make a very good point that a judge might misrepresent what they're seeing because all this stuff is auto-filled. And, there's just not enough new stuff coming down. It's just the same old copies of copies. You got to be your own advocate. That's something I can tell you. And just ask the doctor to do it a little bit differently, or at least to, I reviewed the record for my office visit last Thursday. I note that you did not reference 3 things I told you, and you can do it nicely. Now, that's probably not as nice as I would do it, but there are 3 things that we discussed. I would really think it's important for you to put in your record to help with future treatment. One is that I'm walking with a severe limp because I'm wearing an orthopedic boot. That was not mentioned. I think that's very, very relevant. Number two, that I'm really intolerant to gabapentin. I was prescribed this. I'm having a really hard time taking it. I get nauseous, sick to my stomach, and I have terrible brain fog. And we talked about changing that medication. And the third thing is, I mentioned that I've had, severe elbow pain in my right elbow. I didn't see that on your notes. I think, again, that's relevant for future consideration. Want to make sure that we're all on the same page. And I think if you do it that way, it becomes part of your record, and it also maybe make the doctor slow down a little bit because they are moving, doctors these days, they're dealing with insurance companies, want all kind of reports and don't want to pay them anything, and they move real fast, and they're just boom, boom, boom. And it can be to your detriment in a Social Security case when they do that. Okay, so Nick's talking about all the things that were not mentioned. And again, I think that all these things, I know you talked about getting it. I think you need to get an attorney. I mean, if you're doing an appeals case, if you're not going to get an attorney, make a list of all the mistakes that were made. And I have seen cases remanded by the appeals council by people doing it on their own. If you make a list, but I think it's better to come from an attorney. But, I think you just want to really focus on things that are in the record that your doctor noted and that the judge just misrepresented. Judge says this, the record says that. Here's the page in the record where it says it. But I think you're much better off getting an attorney because federal court work and appeals council work is not for the faint of heart. Okay, Edward is 60 years old, tore his right forearm and right bicep. That sounds very painful. The ER doc says it's not able to be repaired, irreparable, as well as orthopedic doctors said the same, gave you a 20-pound lifting limit, which seems awful high. Moving printers. So even light, the 20 pounds is going to limit you to light. You're 60 years old. So, under the grid rule, you're limited to no more than light. Your past work is moving 100, 300-pound printers. There's no transferable skills. You meet the grid at 202.06. You got a winning case, in my opinion, based on what you've told me. I would take that case in a heartbeat because there is enough here, I think, to win. So that is my take. Peter, still trying to get an SSDI or SSI, put an appeal. Federal courts will wait and see. Pain still hurts. 2 cases this year. The back locked up. Just keep pain diary. I think that would help. And hopefully the appeals council will see it your way. Edward, absolutely. I would take your case as one. I would, again, unless there's something really unusual about it, I would take that case in a heartbeat. You've got, 60 years old. You're limited to light. You meet the grids. I mean, in fact, I would even tell you if you apply it on your own, just argue, please evaluate this case under grid rule 202.06. You might win without an attorney. I mean, I'd love the case, but if you can win without an attorney, go for it. So, all right. But if you want an attorney, call me. And I think you see the case of IO down here. My pain management doctor knows with the curve in your spine, scoliosis, maybe do exercises. Hoping I can win this case when we go back to work. Yeah, I hope, again, I hope so. I hope so. I know this has been a long road. You've been on before. It's a long road. All right. And occasionally lift 10 pounds free, less than 10, standing walk, 6, said to be light. No, occasionally to do light, you've got to be able to occasionally lift 20 pounds. So you're not a light, you're not at the light RFC, you're at sedentary RFC. That's just the way it is. Big Ty, you are very, very welcome. Okay, I got time for a couple more here. The claimant passed CDR recently in combined impairments. Concerns whether templated ROS could create inconsistency. It could. That's where your testimony or written statements can come into play. You can take an SSA form 795 and clarify things that are, if it's in a template, you can clarify using a 795. You are very welcome. You are very welcome. Okay. We'll make this the last one because we're at 2 hours now. 45 years old, waiting for an ALJ decision, 2 months now, migraines, fibro, L4-5, chronic bilateral radiculopathy, severe sleep apnea. CE doctor said less than sedentary. Well, less than sedentary would mean that you win if the judge accepts that. Migraines, fibro, these are subjective, so those are hard. The chronic bilateral radiculopathy can cause severe pain. And obviously the CE doctor said less than sedentary. The big question is your age. If all that's accepted by the judge, you win. If a judge wants to disregard the CE doctor and find you have more capacity than less than sedentary, you can do sedentary work, then you don't win. And judges they can pick and choose. So they can choose a different doctor. Hopefully that will not happen. It's rare to get a really favorable report from a CE doctor physically. So take that as a good sign. So I'm hopeful that you will get approved. So anyway, all right, everybody, I really appreciate it. I'm just going to put this one up here real quick. If you do find this useful, leave me a review. You can go to jonathanginsberg.com and you can see a place to leave me a review if you find this useful. Again, here's a link here if you want to go to bit.ly/Jonathan-review-5. That would be much appreciated. And if you need a case evaluation, just go to bit.ly, contact Jonathan3 or ssdanswers.com. Programming note, I will not be doing this next week. It is the first night of Passover. I'm Jewish, and the first night of Passover, we have something called a Seder, which is a big family meal. And we're not going to do a real big one this year because obviously I have a newborn baby. But I won't be working on next Wednesday. So I should be back the following Wednesday, but not next Wednesday. And a lot of times we'll have like 30 or 40 people over, but not this time. But I do wish those who celebrate Passover a very joyous Passover. If you celebrate Easter, a very joyous and meaningful Easter. Have some non-Jewish relatives in my family, and I wish them a very, very pleasant Easter, and I hope it's meaningful for you. So I will not be here next year. I'll put something out on the YouTube channel, but I do wish everybody the best for the season. I hope the weather stays good and that you are all very safe out there, that gas prices come down a little bit, and that we all stick together because we're much stronger together than we are tearing each other apart, which unfortunately is going on in this country right now. So anyway, everybody take care. I will see you not next week, but in 2 weeks. Take care. Bye-bye.